Hi guys, it's Kathy. I hope you're doing well. So what we're going to do today is go to three different courts in Colorado. Two are brand new judges to you. One, I don't know why. I've only played him a couple times and he's really good. So that's what we're going to do today. Whether you like it or not, that's what's happening. For this one, this lady's a little hard to hear. But when I hear, you can't hear me? Can you hear me? Is that less echoey? I, I, I don't know if that made a difference. Does that make it any better? Oh yeah, I'll have to use my headset because my earbuds broke during last stream. They just stopped working. I was fine, and then last stream I wasn't fine anymore, so now I have to use my headset. All right, I'm gonna unmute that. All right. So this lady right here, we can't hear really well, but that's okay because all we really want to hear is the judge. So after these guys say what they need to say, then we get to hear the judge, and he's the star of this first show. Here we go.
For complaint probation. Condition number one of Mr. Atkinson's, and if I can have that exhibit that you did admit.
I'm sorry.
Condition number one of Mr. Atkinson's probation terms and conditions states that he will not commit any offense and will report any contact with law enforcement probation. A petty offense is an offense with regards to the definition under that and included in that condition. Specifically, if you look at People v. Slayton, which is 878 P. 2nd 106, Colorado Court of Appeals 1994, referencing that for the purposes of revocation proceedings such as this one, an offense would include any violation of a statute or ordinance for which confinement is authorized as a penalty. And that is actually expanded upon in 18-1-104, which specifically includes a petty offense as an offense, and does also under the court notes that under the sentencing structure, 10 days in jail or incarceration is authorized as a penalty for a petty offense, including the petty offense that Mr. Atkinson pled guilty to in 24 CR 192 in Logan County, which was trespassing pursuant to 18-4-503-1A. So the court finds that Mr. Atkinson has violated his probation, and the people have proven by a preponderance of the evidence a violation of conditions 7 and 9, and have proven beyond a reasonable doubt the violation of condition number 1, specifically with case 24 CR 192 in Logan County. So the court does find that people have carried their burden in this case. I will revoke probation on the class 1 misdemeanor. Do the parties wish to go to sentencing today?
That would be the defensive request.
Are the people okay with that?
Yeah, Judge.
Okay. I will hear sentencing argument regarding this matter. Counsel Schomburg.
Yes, Judge. We are here on a class 1 misdemeanor assault in the third degree. From my review of the evidence underlying for the underlying offense is that Mr. Atkinson punched someone while he had a taser in his hand, but wasn't actually using the taser. I guess we intended when he struck the person that it was the taser. it seems to be sort of a when they fight, obviously Mr. Atkinson has been responsibility for a big role in that fight, but Chelsea. We are asking the court to sentence Mr. Atkinson to 4 months of jail under 20 days. Mr. Atkinson was in a very serious car accident in November 2024, so he's hit. He had multiple broken bones. He is still getting follow-up orthopedic surgery for some of those injuries. He had, well, obviously, not ideally, but he had, tried to re-engage with probation in January of 2025, taking active steps that moved for Logan. Due to his injuries in the car accident, he, quite frankly, just had trouble staying on top of probation. However, Mr. Atkinson, can't really show that he was ready to be engaged in the police activities. He does have some other pending cases that he is in custody on. One of which I anticipate that he can come back to you until November. Given that so much trial is set. However, he will be given this for platform misdemeanor. 4 months of jail.
Do you have any idea of credit for time, sir?
Yes, I have 172 days of credit. I can divide the exact dates. Either the 4 or the 2.
Okay, we'll see if that's necessary. Mr. Karchner?
Thank you, Your Honor. So, Judge, we had prepared for trial in this case. We were ready to go. I had worked with Mr. Doolittle quite extensively. Frankly, the only reason this pled to what it did was in light of my victim's position at the time. I very strongly disagree with the characterization of the evidence that counsel has provided. That's not true. You can hear the taser activate. You can hear Mr. Atkinson unilaterally do his best to assault this individual. He claims he was scared and he was basically giving a preemptive strike. But Esteban de la Cruz and a number of other folks at the property, they disagreed with that. Ultimately, he tried to use the taser to harm this person, which is why it was charged as a felony offense, which is why a felony offense would have been appropriate. Given
Where's security when we need her? There's another taser going on and security's not here with us.
the victim's feelings and my access to them, that is how we ended up with a misdemeanor. It was not because the facts aren't serious enough. It's not because the underlying case didn't merit it. That said, Mr. Atkinson does have prior history, pretty significant history of trespass, as the court knows, criminal impersonation, violation of bail bond conditions, theft, several convictions of theft, trespass in the first degree. Probation has been revoked in many of those. The court has seen his efforts to comply and to take seriously not only this offense, but other offenses. For example, he is currently charged with distributing drugs. An offer for that case is a DF3 out of Logan County 25 CR 150. Bond is set in that case at $25,000. He has a DUI pending, a DUR pending, a second degree motor vehicle theft, which I believe were set for trial in this case.
DUR. DUI pending. Got it. DUR. Driving under.
Case bond is set in that case at $10,000 and this particular offense. Frankly, Your Honor, Mr. Atkinson's out of control. I don't know how else to phrase that. Incapacitation, unfortunately, is the only way we can resolve people who have no interest in being a safe person in the community. And that's Mr. Atkinson. I would point out as well, this is an offense from prior to February 28th of 2022, which carries the incarceration requirement of 6 months. I believe an assault 3 is an extraordinary risk, if I recall. 6 months to 24 months in jail. People are asking for 12 months in jail, given the nature of the offense. I understand that it has pled to something slightly different, but Mr. Atkinson has done nothing, has done effectively nothing for this particular offense. This 12 months jail is what I had offered initially as an alternative to probation, again, until access to victims changed. So people are asking for 12 months.
Mr. Atkinson, you're never required to make a statement prior to sentencing, but if you'd like to, you may.
All right, I looked it up. Driving under restraint. It's if you have a DUI, you're not allowed to drive anymore. And then you drive. You get a DUI, you get sentenced, but then you're not allowed to drive, or you need an interlock or something like that. You drive anyway. It's automatic 10 days in jail. It's a misdemeanor.
Judge, Mr. Atkinson just wanted to arrest the record on a couple of things. Otherwise, it's not going to be.
Okay, what would you like to correct?
Does just want to clarify the instances that are pending at Mr. Carter's reference to with that for trial. 2 of those already, and they are with allegation. And Mr. Carter brought up the previous offer. Mr. Atkinson's memory of what the offer was either 6 months jail or 12 months of probation.
All right, guys.
Well, I will first note that
Get ready. Here comes the judge, guys. Here comes the judge.
I'm not going to take into consideration plea negotiations in any case, whether it's this case or in 25 CR 150 out of Logan County. The recitation of a plea offer, I don't think is proper for the court to consider, and I'm not going to consider those. I do consider criminal history when it comes to convictions. I also consider performance on probation. And I am reading the affidavit for warrantless in this case. This case is on video. According to that, the officer observed on video Mr. Atkinson activating a stun gun and hitting the victim in the upper part of his neck and chin with the stun gun. So whether or not the electrical part of it actually made contact, the flashlight portion of it the whole thing was attempted to be used and was used as a weapon in this case, according to the affidavit that was filed by law enforcement at the arrest. I'm not sure how that equates to he didn't activate it. So I just, it doesn't make any sense for the court to look at it and go, this is just a matter of a fight where he punched somebody, when according to the video observed by law enforcement, he activated and used a stun gun in a completed assault that he has admitted to. So.
I just wanted to clarify what I meant.
Okay.
What I meant is the taser was not active when he struck the individual, based off, the underlying discovery I reviewed beyond the warrantless affidavit, the injuries he had on his face and neck were consistent with the taser being active when he was struck.
So, this is important for you to remember. If you do carry a stun gun or a taser, apparently they don't always go off. Like you can shoot someone with it, or you can hold it up to them, and they don't always go off when you want them to, because his didn't go off. Remember that. Remember that.
Okay. I don't think there's any confusion over the fact that the taser was used as a weapon in one way, shape, or another in this case. And I do take that very seriously. I also look at it and it's like, I have not seen a case. I don't think I've ever seen a case where the requirements of probation were so blatantly disregarded for the entire period of probation. I don't have a single UA. I don't have a meetings with probation ended or were being missed within a month and a half of him being placed on probation. And what also is, I guess, troubling to the court, at the time of sentencing, Mr. Atkinson was specifically told, hey, if you comply, we'll let you off probation early. It was 12 months probation, but no objection to termination after 9 months if he complied. And he took that to mean, I guess, that he didn't have to comply at all. And he picked up a new case. He did plead guilty to a new case. He has other cases pending, but the court's not considering those for the purposes of sentencing. This is a pre-2022 change in the law case with regards to sentencing. Class 1 misdemeanor carries with it a mandatory minimum if it's a jail sentence of 6 months. This is an extraordinary risk crime, so it could be as much as 24 months in the county jail. And I believe
Can we just shout out that this is the first court reporter we've seen with a real huge desk? Look at that. She's so lucky. She doesn't even know. What do you believe,
those
Judge?
penalties were included in the plea agreement that was signed by all the parties on May 12th of 2023. The last page of that plea agreement spells out the possible penalties for the Class 1 misdemeanor of assault in the 3rd degree, specifically 6 months to 24 months in jail, fine of $500 to $5,000. Mr. Karchner, did you have any objection to 117 days credit for time served?
No, Your Honor. Mr. Hesacker checked for me. He came up with 115.
Okay.
I think we're close enough.
Fozzie, are you here? Anyway, when I would unmute with this microphone, there was an echo. Am I echoing now? But I have a question to anybody watching, any of my Vibers, probably a replay crew. If you are a court reporter, can you come in here and talk to us? Because we have questions. We have questions how doing this can get all their words exactly to transcribe them. It looks like the keyboard is only this big, and both hands are hitting at the same time. So how is this, Judge? We respect the law and we want to, follow it. How is this capturing all those words? We have questions. So if you're a court reporter, or if you know a court reporter, come on in. No, that's not what I asked. So when I used to unmute my microphone, the video got echoey. Now, when I press play, is it echoey right now?
I have no objection to 117.
I'm unmuted.
Well, in looking at the circumstances of this case and the circumstances of the defendant's probationary performance and complete disregard for the court's orders, court's going to sentence Mr. Atkinson to 18 months in the county jail with credit for time served of 117 days. $117. Mr. Atkinson, you do have the right to appeal your sentence. If you wish to appeal your sentence, you must do so by filing a notice of appeal within 49 days of today's date. You also have the right for reconsideration of your sentence. You must request that reconsideration pursuant to Rule 35B within 126 days of today's date or within 126 days after the Court of Appeals renders a final decision on your case. You also have the right to appeal the court's rulings with regards to the violation of probation and the findings that the court has made. With regards to that, if you wish to appeal that, you must file notice of appeal within 49 days of today's date. You are entitled to counsel for any of those post-conviction remedies. If you wish to have counsel, you just need to request that from the court. The court will appoint counsel for you. You are remanded in the custody of the Morgan County Sheriff for the duration of your jail sentence. I know there are other matters that are ongoing, so that will be coordinated, I think, through the other counties and through your attorneys in those other counties with coordination with this county.
Is that any better? Is it too loud? That's why I'm talking real light. Is that any, no echoey? Now I can only hear out of my right ear. Okay, we're done. We're done with this guy. We're done with this guy. Just calm down, sir. Calm down. Try smiling. Okay. Now,
able to represent myself in a matter
Guy.
based upon the education of my able to represent myself in a matter based upon the education and my understanding of the law. If I were incarcerated and I chose to go pro se, oftentimes they would appoint me advisory counsel to make sure that I understand the facts that are going on in the case. So I will not be without that cushion as well by having the same resource of advisory counsel that I would have incarcerated. I'll just have it out here.
So is your advisory council going to file some type of entry notifying the court of who they are and? what
I'll be
they're-
following all motions under pro se, Your Honor. I
Yes.
will be following motions.
But if
There will be no other motions filed except by me as far as.
understood, I'm not asking for a motion. I'm asking if they're going to file an entry of appearance.
No, sir.
Identifying themselves as your advisory council.
Would that please you, Your Honor, if it did, or would it make a difference? I'll go which way you would like me to go in that direction.
Well, I think it's needed if someone's going to provide you legal.
I'll make sure they
direction.
do. Then yes, sir. Absolutely, sir. I will make sure they do, Your Honor.
Judge, I would just ask that the court make a notation that an arguello advisement would probably be necessary before an arraignment.
Agreed, and I will, it sounded to me that at this point that, Mr. Bramlett was wanting a
That's
pretrial
correct. I'm just
hearing.
wondering how.
I could set that on August 20th, Mr. Bramlett.
I don't know the procedure. Do we have a motions date? I'd also like to file the Rule 16 with the attorney here. Making my appearance as pro counsel. I'd like Rule 16, any evidences or anything that has to do with this case. I would like as much as possible to have as soon as possible. If we could set a motion for that under Rule 16, Rule 29. As well, I would like to find out a date that we can set for maybe initial motions or maybe prelim, if that is the procedure in this matter.
I think the first step from my perspective is going to be setting a preliminary, just a pretrial conference
Okay.
on August 20th. We can look at setting a date or deciding how we want to proceed on it from there. But initially, I'm going to set a pretrial conference on August 20th. The district attorney who's typically here, in this county is not present today. So without that, Mr. Bullock being present, I don't want to be setting hearings or other matters until he's present. That'll be August 20th at 1:30 p.m. Also appears, Mr. Vogel, to be a case in which one, I need to issue a fingerprint order.
What time, sir?
August 20th
Uh-huh.
at 1:30 p.m.
You guys see it, this is school. I see it as best.
Mr. Bramlett, I'm also issuing a fingerprint order.
Basketball.
You have the instruction, there's some instruction information sheet on that sheet on where you can complete that. You have 28 days to get that completed.
Absolutely. Just as also a matter, well, never mind. We'll talk about that.
There's a number on there for an individual that you need to contact, Nicole Mestis. That telephone number is provided on that. You have, so her telephone number is provided on there. You can contact her so she can provide you the exact location that you need to be able to complete that fingerprint order.
Yes, sir.
Mr. Vogel, this also appears to be a case in which we need a mandatory protection order, given that there's a charge under Title 18.
Judge, I would defer to the court on the conditions.
Mr. Bramlett, court is going to enter into a mandatory protection order. That is going to be that you shall not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the act with which you are charged with committing. I don't see that that was entered at the initial hearing that you had. So the court is going to enter that order at this time. Any violation of that could result in additional charges as well as a contempt citation. Do you understand?
Yes, sir. I
Okay.
do understand that.
So we'll have it set over for the pretrial conference. That'll be August 20th at 1:30 p.m. Anything further, Mr. Bramlett?
No, sir. I do appreciate your time and I thank you, Your Honor, for your taking a look at this.
Thank you. Mr. Vogel, anything further?
No, Judge.
Or I'll close the record then in 24M 114.
Thank you, sir.
Have a good day.
You as well.
I don't know where this is. I mean, it's Colorado. I just don't know which county in Colorado this is. However, I think his hearing on August 21st is going to be a bit interesting, don't you? It sounds like he has standby counsel, which makes it either, I don't know, more interesting or less interesting. Lana, I'm so sorry you were sick. That sucks. All right. I think there's one more guy here we'll go through. I don't know if they're interesting or not. He was. That's why I got this.
Colorado versus Devin Reimheimer. Court notes the appearance of the people by Mr. Vogel, notes the appearance of Mr. Reimheimer in person on this matter. This matter was set for a review today, set at 11:30. There was no appearance at that time. The court did not take up the case at 11:30. In the event that Mr. Reimheimer appeared this afternoon, it was really set for a review as a part of the plea agreement that was entered. Mr. Reimheimer is to provide proof of medication as well as continuation in therapy and mental health therapy. Mr. Reimheimer, do you have any paperwork indicating compliance with your medication regimen and therapies?
Actually, at the moment, I have not been able to get my Medicaid up to date. So I haven't been able to get my medications, but I have been doing making my appointments with the Southeast Health or whatever in Lahana.
Okay.
I don't have any paperwork though.
Are you able to get some paperwork?
Yes, if I need to, what paperwork would you be wanting?
Well, I want to see the appointments and make sure that you're still attending regularly, your appointments for that. I don't know if they can assist you in getting your medications as well, but as part of the plea agreement was continuation of the medication regimen and maintaining your therapy.
Yes, Your Honor.
I'm not counsel of record, but is the court able to appoint Bridges to assist with this since it is a mental health issue? No?
And I'm not opposed to appointing someone if we can do that. I guess
And she would be able to help facilitate reports. I know that's not the normal role, but I know she would be able to at least assist with the Medicaid piece if she's able to be appointed.
well, to the extent that we can appoint Bridges, I'll appoint Bridges to assist in this matter and see from Ms. Kendall's perspective if she can assist on this case. But Mr. Reimheimer, in the event that there isn't someone able to help facilitate this, I do need you to provide a list of your appointments, okay, that you've attended over the last couple months and that you're currently scheduled for, and then a list of the medications that you're taking. Obviously, making sure that you get back onto your medication regimen is important. Mr. Vogel, anything to add on this?
No, Judge.
Ryan Hunter, I'm thinking of setting this over to August 20th, just to see, one, if Miss Kendall's gonna be involved, and two, if you can get me copies of those, the medication list as well as the therapy sessions that you're attending. Are you going, when's your next appointment? How often are you seeing your therapist?
I've been seeing my therapist or the therapist monthly.
Okay.
You did want me to pick up on weekly, correct?
I mean, I don't know that it's stated in the order as to how much, how often. You recall, Ms. Ferguson? Well, I'm gonna set you on August 20th anyways, just to see if Miss Kendall's gonna be around and if you can obtain some paperwork, or if they will, if you sign a release so that they can send us paperwork, that would be.
If you guys hear the judge's name, let me know. It is not Jalen Baylor. It is not Joshua Vogel. And it is not Los Animas Cartwan. This is, I think, either Baca or Bent County. But I'm not sure. So on August 31st. I'll be able to find it because look at that courtroom. It's very unique. I just would have to click into every single Colorado link to find it. But I'm going to try to find this case. I just don't know the judge's name. That would help.
Be helpful so that we can see that you're making progress and continuing in services.
Yes, Your Honor.
So August 20th, that's going to be 11:30 a.m. Okay.
Okay.
I'll reach out
All right,
to
thank you.
Kendall so she has an idea why you guys are trying to contact her in this case, since it was my idea to interject her anyways.
Okay.
All right, take care. Good to
All
see
right,
you.
I think we're done with this
You look good, Devin.
courtroom.
Miss Ferguson, do you have a phone number for Mr. Einpiner? Or can you provide us one so we can provide to Miss Kendall or vice versa?
Do you have a good number?
Hold on, Miss Ferguson.
Okay.
Or we'll close the record in this case.
Oh wait, I spelled it wrong. I have no backspace on my keyboard right now because Anthony stole my keyboard and gave me his.
Judge, I was told that Miss Erica might be in the Pueblo jail, but every time I try to pull up Pueblo jail, I can't get the inmate locator thing to work.
Pueblo.
Sue calls into the WebEx line.
I mean, this could be Pueblo. It's not Lamar. I mean, I'm not saying what you typed is wrong in any way, shape, or form. All I'm saying is this isn't Lamar, but that makes sense for Colorado because in Colorado, like the courts are just like they hear cases from all over the place. All right, like Judge Eric. Judge Eric sometimes has 6, 7 counties that he is presiding over. He's in Denver. He's in Boulder. I know he's in Denver. I do not know if he's specifically in Boulder now that I said that, but I think so. But he hears cases from all over the place. Judge Blanco with the mental health court, she hears cases from all over the place. So, yeah. So I'm fairly certain this is not Lamar courtroom, even though Joshua Vogel is the prosecutor for Lamar. That is a fact. I'm not disputing that. I think that this is Bent or Baca. And if gun to my head, if I had to guess what this is Bent. But I'll figure it out on the 21st. I will. I'm gonna look for her actually. I'm gonna look where she is on the 21st. All right, so there was one more, but that looks real short. Okay. Let's go to, I don't know. Okay, this one, I can't remember his name off the top of my head, but we freaking love the judge that is normally in this chair. He has like salt and pepper, but mostly gray hair. Like a little scruffy. Oh, he's so snarky and he's so hard and he's so anyway, if you remember the courtroom layout, you'll remember the judge that usually sits in this chair. He's very, very tough. 100% not someone you want to get in front of. So we have a new judge in his chair today. This is Boulder, which is rare because I usually steer clear of Boulder, the actual Boulder link. I get Boulder from all these other counties, but um, we're gonna see how she does in his chair.
He's 57 years old. He has minimal criminal history. He's lived in Colorado and been employed in the catering business for the past 6 years. Tells me he's an attorney in Florida, but no longer practices and finds catering to be less stressful. But in any event, I would ask the court to consider a personal recognizance bond as recommended by the by the bond commissioners. And if
He finds catering to be less stressful than an attorney. Are you kidding me? Guys, if you've ever worked in the food industry, it is very stressful. It is one full stress the whole time you are there. Stress is maxed way off the charts.
I think enhanced supervision would be something that would help Mr. Rathbun ensure that he make it to court and keep on top of his obligations. If not, I'd ask for a $1,000 secured bond with a $100 cash option.
In 25 CR 1136, the court is going to set a 2,500 cash or surety bond. And in the 25M 581 case, the court is going to leave it as a $1,000 cash or surety bond. Part of my concern is that it looked like Mr. Rathbun had failed to appear for a pretty significant hearing, and I think he was set for jury trial in the misdemeanor case, and it is concerning that there's a new case picked up. Part of the conditions of that bond are going to be that he not have any contact with the victim or the residents, be supervised by pretrial services, report to pretrial services within 24 hours, to not possess any alcohol, no weapons, and the court will authorize a civil standby. The court is ordering a mandatory protection order in this case, Mr. Rathbun, that you not have any contact with the named victim in this case. Did you receive that?
Yes, Judge.
Thank you. All right. The court is going to leave we said in the 25M case, the conditions of bond had already been set. Those will remain. And that will go ahead and trail this case. Next court date, please. August 12th at 1:30 for filing of charges back here, okay? All right, thank you.
Your Honor, I would ask the court to consider a cash option in 25 CR 1136, given that the recommendation was for a personal recognizance bond. And oftentimes, if folks don't have the collateral necessary to satisfy a bondsperson, they simply can't get out. And that $250 will be a lot of money to Mr. Rathbun. I think he can come up with it. I'm just not convinced he can come up with the collateral.
I understand. Our next court date is going to be on August 12th. I will have the court reconsider that bond, but at this time, I'm going to go ahead and leave it set at that 2,500, okay? All right, thank you. Court calls 25 CR 1138, People v. Soren Roller.
Yasmin Forzanda with the public defender on behalf of Mr. Roller.
All right. Mr. Roller, Ms. Andrea, it looks like also charges were filed, or nope, not yet.
So what I was able to glean was that in 25 CR 1109, earlier this week in front of this court, charges were filed and a preliminary hearing has been set for August 28th at 9 a.m. In the meantime, there was a report of Mr. Roller allegedly trying to open a door back on August 2nd. So he's been in custody since
Department of Mysteries, I bet.
Since he was picked up on the pre-existing case. So I think bond needs to be set in this matter and set for filing. I don't know if it could be all
Set together?
set together, but that's, I think I'd leave that up to the district attorney's office. I would also ask the court to consider the fact that, I don't know, I'm not convinced there's probable cause for the charges alleged here. Burglary an attempted burglary. It's all they have is him allegedly trying the door and looking in a window, and that's it.
The people's position?
Your Honor, I do think there's probable cause for these charges. And I won't make a record in front of Your Honor that there's overwhelming evidence in this case. But still, the standard for an attempt is a substantial step towards the burglary. I do think there's a substantial step here with the video of the defendant trying to enter a home. And again, being caught on video doing so, I do think that's sufficient for there to be probable cause.
Position on bond?
In regards to bond, I would ask for a $2,500 cash surety or property bond. It does look like there's been some escalation recently with the defendant. And then I also just note 5 criminal convictions, it looks like, since 2020.
Court's gonna set a 2,500 cash or surety bond with a 250 cash option. Conditions of that bond are no contact with the victim or residents. Report to probation within 24 hours and no weapons. Mr. Roller, there was a protection order issued in this case. Were you able to review and sign it?
Yes.
Okay. We're going to set this, we're going to set your other case with this case for filing of charges on August 12th at 1:30. Okay, we'll see you then. Thank you.
Thank you. Right, sir.
Okay. Court calls 25 CR 1139, People v. Michael Simmons.
Mr. Simmons is present in custody. Yasmin Forazanda with the public defender on his behalf. He has been over the protection order, agrees to it, and does have an alternate place to stay with
Okay.
his mom, his parents.
And Your Honor, the people do not object to a personal recognizance bond, but with that, with the facts of this case, I know it's not recommended. It doesn't seem like by the bond commissioner, but given that it seems like Mr. Simmons was so intoxicated that he doesn't even remember the event happening, I would ask for pretrial supervision and alcohol monitoring at their discretion. And conditions of no alcohol.
Let's see here.
And I also just note 3 prior convictions. They are old, but for DWAI, DUI, and DUI, the last one being in 2008.
Okay. The court will set a 3,000 PR bond. The conditions of that bond are that you not have contact with the victim or residents. No alcohol. Will allow a civil standby. Pretrial services. Report to pretrial services with 24 hours. And alcohol monitoring at the discretion of at pretrial services. Mr. Simmons, did you receive the protection order? Thank you. Oh, I'm sorry. Hold on. Let me unmute you. And can I get a verbal?
Yes, ma'am. I read over and I signed it.
Thank you. Okay, next court date, please. August 12th at 1:30. That will be your next court date. Thank you. Oh, Mr. Simmons, I just want to make sure that you reapply for the public defender's office, right? Because we're giving him a PR bond.
Right.
Okay, all right. So you'll need to make sure that you reapply for the public defender's office, and then it's going to be, the court is going to be back here at 1:30, okay?
Apply.
But make sure you apply.
Okay.
Thank you.
The person in the gallery is a good time on perhaps this case. Okay. I just want to call it maybe before we get to the last one. Since it's yeah.
I feel like, oh, didn't we already call that case?
We did call that case.
Oh, what's that?
Which case is it?
25M1628.
So I don't know if that's the case that she's here on, but I
Oh.
remember her standing for one of our misdemeanors.
Hold on, let me see here.
Yeah, I was wanting to potentially make a statement about the case of John Jensen and Schaefer. I am the victim, so I don't know if you can reopen that or not since you guys already called it out. But
Mr. Schaefer, I apologize. Were you in the gallery? At
Yes,
the time
ma'am.
that I had called it. I apologize.
You're okay.
Sorry, Judge, I didn't have notification prior to court.
Okay. Give me just 1 minute, okay?
Okay,
I
thank you so
apologize for not
much.
seeing you
No, you're okay. Thank you.
And a PR bond was issued, Judge.
in that case.
In that case, yeah.
Oh, okay. Okay. Go ahead and address the court. I apologize that we did not see you.
You're okay. I just was wondering if I was able to potentially lessen the protection order or completely get it away.
Ms. Richardson.
My suggestion at this time, as the defendant is not here, is that she reach out to our victim advocate, which I believe she's already spoke with, and they can, she can fill something out and that can be filed into the case.
Okay. The district attorney's office is recommending that you file just a letter or something with them to request the modification. And then the court can address that at his next court date.
Okay. Yeah, I was given a blank form to fill out, and then today, I believe her name is Marcia Leon, told me that I would be able to verbally do it.
Okay.
But
That's fine. I know that you are here. A record has been made about your request. I will put a note in here that you appeared after the case was called, but that are requesting a modification. And what were you requesting?
just actually full contact, being able to see each other again and everything.
Okay, I'll note that your request. I can't tell you that that's what the court will do or what the positions will be at the time, but because we've already called the case, I will just put that into a note in here that you verbally requested full contact, okay?
Okay, thank you
Alright.
so much.
And since the court is taking that note, is the court requiring that people file something in response to this verbal record, or would you ask that she file something with our office and we file it into the case? And then give us a chance to put our
Position on it?
stance with that filing.
What will be easier for you, Ms. Richardson?
I think just because the defendant's not here, I think it would be better if she just filled out the form that our office provided her at this time, and then we can file our position along with it.
Okay, all right, that sounds good. I am taking note of your request, but if you could file that, and then the district attorney's office can also then coordinate and do a response.
Okay,
Have her email address.
mail her the form back?
Over the form, and then
Okay.
the attorney on the case will file it into the case with their position as well, okay?
Okay, thank you also so very much.
No, thank you, and again, I apologize that I did not see you.
You're okay. Thank
Okay,
you again.
Thank you.
Now we are going to Colorado. Yeah, I know. He'll turn it on in a second.
In detail with
There
your
we go.
lawyer.
Okay.
We-
This is the other judge. I said we had two new judges. We just saw the two new judges. This is one that I've showed before. Not recently. It's been a good few months since I showed Judge Grant, but we do love Judge Grant.
Paperwork for the court's acceptance.
Okay. Mr. Fluker, I'm going to be going over some things with you. If you have a question or don't understand something, make sure you get Mr. Cooper's attention, okay?
Yes, Your Honor.
Start off by having you state your name.
Tevin Fluker,
And how old are you?
34,
How far have you gone in school?
GED.
I assume you read, speak, and understand the English language.
Yes, Your Honor.
Are you thinking clearly today?
Yes, Your Honor.
Are you taking any prescription medication, pill, drug, or alcohol that's interfering with your ability to understand the nature of this proceeding?
No, Your Honor.
Are you suffering from any mental or emotional condition that makes it difficult for you to understand what's happening?
No, Your Honor.
The agreement, as I understand it, is you pleading guilty to count 2 motor vehicle theft in the second degree, a class 4 felony. Counts 1 and 3 to be dismissed. There's an agreement to 4 years DOC with restitution in the amount of $3,215.47. Is that your understanding?
That is my understanding.
Did you have adequate time to talk about the details of this agreement with your lawyer?
Yes, Your Honor.
Are you satisfied with his representation of you?
Yes, I am.
Okay, I've been handed plea paperwork. That's going to be part of your case file. It's called a Rule 11 advisement. It has initials next to numbered paragraphs. Are those in fact your initials?
Yes, Your Honor.
And on the signature line for Tevin T. Fluker, are those in fact your signatures?
That is,
These documents contain the elements of the charge you're pleading guilty to, the possible penalties for that offense, the rights you're giving up by pleading guilty, and the agreement that's been reached. Did you have adequate time to review these documents in detail with your lawyer?
yes, Your Honor.
We afforded the opportunity to ask him any questions you might have had. Did he answer those questions to your satisfaction?
Yes.
In light of that, what is your plea to count 2 motor vehicle theft in second degree, a class 4 felony, guilty or not guilty?
Guilty.
Before I accept your guilty plea, I want to make sure you understand that you have a right to have a jury trial, at which time the district attorney would have to prove all the elements of the charge beyond a reasonable doubt to a jury of 12, and the verdict would have to be unanimous. At that trial, you'd have the right to testify or not testify. You'd have the right to call and subpoena witnesses and cross-examine those witnesses called by the prosecution. You also have the right to be represented by an attorney at that trial. If you could not afford one to be appointed to represent you at no cost to yourself. Finally, if there were guilty verdicts, you have the right to appeal those verdicts to higher court. Do you understand that by pleading guilty today, you're getting up all those specific rights?
Yes, Your Honor, I do.
Other than the agreement that I read into the record, have there been any other promises made to get you to plead guilty?
No.
Is anyone forcing you or putting pressure on you to do this?
No.
Are you doing this freely and voluntarily?
Correct.
Mr. Cooper, factual basis.
We'd waive, Your Honor.
Sir, do you have any final questions on myself or Mr. Cooper?
No, Your Honor.
Is it still your wish to plead guilty to count 2?
Yes, it is.
It is please accepted. The court will make written findings regarding accepting the plea, noting it was knowingly, intelligently, and voluntarily entered. Judgment of conviction enters as to count 2. Counts 1 and 3 are dismissed. And I assume we're going to meet at sentencing.
Yes, Your Honor.
Anything else, Mr. Kaminsky?
There's just that restitution, nothing further.
Anything else, Mr. Cooper?
That restitution's agreed upon.
Okay.
Given his agreement to a DOC sentence, I'd ask that the court waive any additional fines or costs.
Okay.
On this matter, he has 117 days of pre-sentence confinement credit. We've resolved this globally, essentially, with the probation revocation matter as well. On that matter, he has 173 days of pre-sentence confinement credit.
Okay.
And that would be a 1-year DOC sentence concurrent.
1 year, okay. Mr. Fluker, you understand that in your probation matter, by pleading guilty in the new case, that's a violation of your probation?
I do, Your Honor.
Anything you want to say?
No, thank you.
Okay. Court will sentence you pursuant to the agreement to 4 years DOC and 25 CR 2067. Restitution's ordered the amount of $3,215.47. 117 days of pre-sentence confinement credit in 25 CR case, 173 in the 24 CR case. I'm waive fees and costs in both matters in light of the restitution. And in the revo, that's 1 year DOC with a 2-year period of mandatory parole and 3-year period of mandatory parole in the other matter. Again, everything running concurrently with each other. And I wish you the best of luck, sir.
Thank you, Your Honor.
Good luck. Absolutely. Can we set up a breakout room, Ms. Mayhew?
Okay. We'll set up a
It's tough because
breakout room.
So Holly, in your email,
Get it.
you agreed on
it's her enrollment.
I'm just making sure line by line, I've got this.
Maybe it's still on
on-
case.
4125 is the sex assault.
Or 471.
Or 90, no credit. Okay, so I switched that by accident. Unless it's DV.
Yeah, 60 days.
Hmm.
60.
What was the chart? What was the F6 again? Yeah, 4471's the sex assault. Yeah. Okay. Was there a new case? Yep. And then which DF3 are you, the new DF3, the one he's pleading to, you're agreeing is 3 years?
Yeah, so the DF3 that he pled to.
The Revo, okay,
He pled
got it.
to.
4471.
Can we set that up for Ms. Mayhew? What was that?
Yeah, 4 to life. Yeah, maybe that's the DV case. I don't know.
And then I paid.
So he had an Arapahoe case too, that was second degree murder. It's not new. Oh, that's the DV. You know what's going on? So you're saying that's why you both counts are concurrent?
Yeah.
Not to both cases, but he has 2 other DF3s.
Yes.
So,
And those would just be.
okay, okay.
The F6.
Ms. Mayhew, we're going to be linking you up with your lawyer here shortly, okay? Thank you.
So I'm gonna
On
bump
that
it
F6.
to after she gets done with her lawyer.
Now,
She's back, but the judge is not back. There we go. I know there's no sound. Don't worry. The judge will unmute in a second. See, he's muted. You can see it right there.
Ms. Mayhew, can you hear us?
Do you want to know why I got Judge Grant for this? If you look, this is Denver. This really legitimately is Denver. And Eric Johnson is Denver. But he wasn't streaming. He wasn't streaming when I did this, so I had to go to Judge Grant instead, which is fine. He's great.
Okay.
Yes, Your Honor.
Tom Dunlop, pardon me, Tom Dunlop on behalf of the people.
Okay.
Clark Cooper on behalf of Miss Mayhew. She's present virtually in custody from Arapahoe County.
This is 26 on the docket, 24 CR 5440.
She's set for an appearance on arrest warrant. I think the first thing that we need to accomplish is getting a bond set. I have a brief argument for the court whenever it's ready.
Okay. Go for it.
Miss Mayhew just pled on a F6 motor vehicle theft case with me on June 9th. I worked out this case with Miss Olin. There's obviously the agreement to probation. There's absolutely zero failures to appear by Miss Mayhew on this case that I've seen through the history. She appeared 2, 3, 4, 5, 6, 7, 8 times on bond. I don't think that return to court really should be an issue or a concern of this court. What I do think might be of concern to the court and would like to address is that Ms. Mayhew picked up a new case in Arapahoe County that is set for preliminary hearing on August 20th. It is not of similar nature, though what I saw was a attempt escape charge.
What about the motor vehicle theft? Doesn't she have like a pending?
In the
one of
complaint,
those?
I saw just the escape charge. Was there another case number?
See in the complaint. Arapahoe County case 25 CR 1643, first degree motor vehicle theft.
So it would be 2 cases then that she picked up, Your Honor. That's correct. The F3 motor vehicle theft, and then the attempt escape charge or the escape charge. Given her compliance while on bond with regard to return to court and not picking up any cases during the pendency of this case, I think that with some safeguards that Ms. Mayhew obviously will return to court, but also won't be picking up additional cases, which I would understand being a concern of the court here. Ms. Mayhew has been working with getting into First Step. I believe she's been accepted into First Step, which is a bed-to-bed sober living facility. And I just can't speak too much as to the Arapahoe cases. I'm unaware of, other than now the charges on both, what really is going on there. So I would ask that the court consider a personal recognizance bond with, I don't know if we can necessarily do pretrial supervision, but a personal recognizance bond on the probation revocation here, Judge.
Mr. Dunlop, whenever you're ready.
Your Honor, it looks like going through my notes that what previously assured her presence in court started as a $5,000 cash property surety bond and a $2,500, which was lowered to $2,500 at one point. The people's request is $5,000 cash property or surety when this was initially set, and that was securing her presence. I think this was the only case at that time. Now she's picked up 4 in 1 year. It sounds like the escape is for a proper escape from a courthouse. So I do have some concerns about her willingness to reappear and believe that's an appropriate amount.
Yeah, I'm just concerned about continuing to steal cars. So, I mean, I don't know, the incidentals, the new case, you see something here. So new cases out of Arapahoe, 25 CR 1643.
Case that I had looked at, Your Honor, is 25 CR 1667.
Okay. Her bond in the motor vehicle theft is $20,000. Cash property surety.
And it looks like on that other matter, I'm showing a $2,500 bond.
So I'm just looking at the arrest affidavit in the new case. Stolen vehicle, allegations Ms. Mayhew's driving.
Thank you.
I'm gonna put bond $5,000 cash property surety. I believe she'll show up, but I don't believe that she'll stop stealing cars, so at this point. And we need a new date.
Yes. She's set on the 1667 case for prelim on August 20th, and I think she's also set on August 20th for prelim on the other matter. So if we can set shortly after August 20th, just to see what happens with prelim or different offers.
September 5th, 8:30.
Fine for me.
We'd wait 14 days.
We we'd waive the 14-day rule
Okay.
for revocation hearing.
Okay, we'll just set it for status. And we'll do a writ to Arapahoe just in case. Okay, Ms. Mayhew, thank you for your patience today, but we'll see you down the road a bit. Yep. Okay, next case.
This is Mr. Gallegos looking
Moses Gallegos.
14 on the dot.
Yeah, 14 on the docket, 23 CR 2501. Mr. Gallegos, good afternoon. Thank you for your patience.
Tyler Tominski for Heather Olin for the people.
Maisie Horn from the Public Defender's Office on behalf of Mr. Gallegos, who does appear with me to my left in custody. Your Honor, we do have an agreement whereby Mr. Gallegos would be admitting to violating the terms of probation, and he would be sentenced, re-granted probation for 30 days, with the sole condition being 30 days jail, no prior credit.
It can't be the injustices of the system, Alan. No, no. Let's move on from that. This is a happy place.
Okay. Okay, Mr. Gallegos, is that what you want to do today?
Sir.
Okay, I'm going to go over some things with you. If you have a question or don't understand something, get Ms. Horn's attention, okay?
Sure.
Start off by having you state your name.
Moses Gallegos,
How old are you?
43,
How far have you gone to school?
2 years of college.
Okay, so I assume you read, speak, and understand the English language.
Yes, sir.
Are you thinking clearly today?
Sir.
Are you taking any prescription medication, pill, drug, or alcohol that's interfering with your ability to understand the nature of this proceeding?
No, sir.
Are you suffering from any mental or emotional condition that makes it difficult for you to understand what's happening?
No, sir.
Probation Department filed a complaint. They're asserting that you violated one or more conditions of probation. Do you have an opportunity to review that complaint with your attorney?
Yes.
And are you satisfied with her representation of you?
Very.
In light of that, do you admit or deny that you violated probation?
Admit.
Before I accept your admission, I want to make sure you understand that you have a right to have a hearing to address that complaint. The hearing would take place in front of a judge. At that hearing, the district attorney would just have to prove that's more likely than not that you violated probation. And do you understand that by admitting today you're giving up your right to that hearing?
Yes, sir.
Okay, court will accept your admission. Immediate sentencing, I assume?
Yes, Your Honor.
Anything else, Mr. Kaminsky?
No, Judge.
Anything else, Ms. Horn?
No, Your Honor.
Okay, Mr. Gallegos, anything you want to say?
No, sir.
Okay, court will revoke and re-grant probation, sole condition that you serve 30 days Denver County Jail, no credit towards that, and terminate as unsuccessful with the completion of that jail time. Good luck.
Thank you.
Thank you. Ms. Cooper, Ms. Mayhew, do you want virtual writ or in person? Virtual's fine.
I'm hoping there's one more here. Oh, this guy. Hold on, I'm thinking. Okay, this one's okay. This one is, I didn't get the very, very beginning because I was on this guy.
30 miles. So it depends, like he'll go up to Boulder and ride, but
Once he started talking about personal life, I moved it to another courtroom real quick.
You contacted here today?
Yes, ma'am.
This courtroom.
Can you identify him by what he looks like and an item of clothing he is wearing?
Glasses, goatee, black t-shirt.
The police are on
Your Honor,
trial
may the
here.
record reflect that the witness has properly
They're saying that Miranda rights were violated.
identified the defendant.
subject to cross, the record shall so reflect.
Now, when you observed the defendant exit out the vehicle, did you notice any indicia of impairment?
Yes, ma'am. He was, his eyes are red. When I asked him why he did not stop, he had slurred speech.
Now I want to take it back to the defendant's eyes.
Okay, I can't find it in chat. But Kelly
When you said they were red,
Kelly sent a bit on Twitch 8 minutes ago or so. It didn't it's not on my chat, so I can't see it here. But thank you so much. And then Monica cheered 100 bits. Thank you, Monica. And then Monica cheered 1 bit 3 minutes ago. Thank you, Monica. And then Kelly cheered a bit 3 minutes ago. Thank you so much. I appreciate it. I'm sorry. I have to watch both chats. I forgot.
Would you say they were watery or and bloodshot red?
Yes, I would.
And you said the defendant's speech was slurred. Did you smell any odor of alcoholic beverage on his breath?
Yes, ma'am, a non-alcoholic beverage.
So after this, did you ask the defendant anything?
So the first thing, when he got out of his car, I asked him, why are you getting out? He told me because he didn't want me to tow his vehicle. He stated, I didn't ask anything else. He stated he had a couple of drinks. Then he was placed into custody and read his rights while he was in the back of my vehicle.
Did you ask him why he didn't stop for the lights and sirens?
That's the reason I was asking, because as I was getting out, he was getting out. So I didn't know if he was gonna try to go inside his house or something. So as I was walking up to him to contact him, I was, hey, why didn't you stop?
Now, at this point of contact, was the defendant under arrest for anything?
When I asked him, no, because at that point I was pulling him over for a traffic violation. It wasn't until after I asked that question that I observed the bloodshot eyes and the slurred speech.
God bless you, Judge.
Were you investigating?
I mean, I was getting out, so I mean, it was a traffic stop, so I was investigating the traffic stop and why he didn't stop.
What happened after that? Oh, actually, if I could adjust my question. Now, when you, I'll give the interpreter a moment. Now, when you saw this indicia of impairment, these bloodshot, watery eyes, slurred speech, odor of alcohol on his breath, and slurred speech, did this become a DUI investigation?
At that point, yes, I had suspicion of DUI.
Then what happened after that?
After I took him in to place them in handcuffs,
Well, so at this point, you've determined this is a DUI investigation. What happened after that point?
because he was trying to get out of the car, he was placed in handcuffs. He was placed in the back of my car. He was read his Miranda rights, and then he was asked if he would like to do road signs.
Now to go back to Miranda, did the defendant agree to speak with you without an attorney?
He did.
And during your further conversations with the defendant, did you still smell an odor of an unknown alcoholic beverage on his breath?
I did.
Then what did you do next?
He refused to do roadsides, so he was taken back to my substation.
Did you run his name through NCIC or CCIC as well?
Oh, I'm sorry. Yes, I did.
And what results popped up?
He had a warrant for a prior DUI.
Mhm. Did you see anything regarding his license?
If I can check, I can't remember right now, unfortunately.
Go ahead and review your report, and then once your memory's been refreshed, go ahead and flip it back over.
Is your recollection refreshed?
Yes.
All right, now when you ran his information or his name through CCIC and NCIC, did you see anything, alerts regarding his driver's license?
Yes, ma'am. It showed that his license was revoked.
Do you recall what for?
I believe DUI.
Did he have any other additional active warrants?
Not that I'm aware of.
Do you recall six additional active warrants?
No, not right now.
Relevance.
I will move on.
Thank you.
Then, did you advise him of the Colorado Express consent?
Yes, I did.
And what was his response after that advisal?
He just refused to talk to me. He refused. He understood what I was saying, but then after that, like I said, go trying to do roadsides, and if he would want to do that after telling him, his license will be taken away if he refuses, he still didn't want to do them.
So it's safe to say he refused chemical testing.
Yes, ma'am.
Did the defendant have any valid registration or insurance on his vehicle?
No, ma'am.
And regarding the plates, did they belong to that black pickup truck or another vehicle?
A different vehicle.
Do you recall if it was a valid plate or was it canceled?
I don't recall. I remember it was often a GMC Acadia, which is a SUV, not a pickup, but.
So after this point, what happened?
After like he's at the sub or before? After he refused, he was taken to my substation.
Prior to going to the substation, so he was parked in front of a residence. I want to give him a minute. And did anyone come out the house?
Oh, yes, I believe it was his nephew. It was a little boy.
What happened when the nephew came out the house?
We were still we were on the side of the pickup in front of the house when the little boy came out. He asked me what was going on. I advised him since he was a juvenile, I couldn't share any information with him. I didn't ask him anything else after that, but he just said on his own that his uncle's probably in trouble for drinking again and that he has a drinking problem.
Now, after this, was the defendant placed in your patrol car?
Yes, ma'am.
And while he was in the patrol car, did you smell any alcohol on him still?
Yes, I could smell it from the front seat of my vehicle.
All right, then what happened after that?
He was taken to our substation. He was processed, and then he was taken to jail.
And did that conclude your involvement with the investigation?
It did.
No further questions?
Cross-examination.
Yes. All right, and then could you tell me your name one more time, officer? Sorry.
Yeah, no problem. Full name?
Yes.
Claudio Hernandez Jr.
Hernandez, okay. Okay, Officer Hernandez. I just want to start by, I guess, talking about the driving behavior that you observed. So you say that you initially started your lights to pull Mr. Garcia over due to his license plates?
Yes, sir.
And I think before that you had said you'd seen him like backing out of like a parking lot or something.
So the way the street, it's a street. There's a liquor store off the main street. There's parking right next to it in front of the liquor store. So he was backing out onto the main. It's the only way he could back out to get it out of those spots.
Okay. So it's like a parking lot on the street or like a parking space on the
exactly.
street.
Okay. Yeah.
And you say that when you started your lights, it had taken him a little bit to pull over.
Yeah, it took a long time.
How long do you remember?
And let's pause for 1 second. I think we're making a transition.
Switching over. Okay.
Yes. So I think we're releasing Mr. Arrieta from the bridge line with Ms. Kent being here in person. Do you need a second to get anything set up or any headphones? Thank you, Mr. Arietta.
Glad to help you, Your Honor. Have a great day.
You too. Take care. All right, let's just take one step back.
Sure.
If you want to re-ask your question.
Okay. How long can you estimate did it take him to pull over?
I can't give you an exact time, approximately anywhere from 2 to 5 minutes.
Okay. How far was it that he drove?
Maybe 4 to 5 blocks from where I originally attempted the traffic stop.
Okay. And the speed limit was 25 miles per hour that whole time?
Yes, sir. But there's also stop signs on the streets as well.
Sure. And you said Mr. Saucedo didn't exceed 20 miles per hour?
No, sir, he didn't.
And that he was obeying other traffic laws that whole time?
He was.
Okay. So he had stopped for the stop signs?
Yep.
Okay. So you didn't ever see him like following other cars too closely or anything like that?
No, I don't believe there were other cars on the road at the time.
Okay. Did you see him brake suddenly?
No, not probably until he got to in front of the house.
Okay. He was using his turn signals?
I don't recall, to be honest with you.
Okay. But you don't recall any other, I guess, bad driving at that time?
No, sir.
Okay. Now, when you got to the car, I guess once he was pulled over, you say he exited the car when you were pulling up?
Yeah, at the same time I was getting out of my car, he started to get out of his car.
Okay.
Let's pause for 1 second. I appreciate the multitasking.
Yes. And then you say you saw the red eyes and smelled alcohol.
Yes, sir.
And also slurring words.
Yes, sir.
Other than that, were there any other indicia of intoxication that you saw?
No, sir.
Okay. Were you speaking to Mr. Garcia in English or Spanish?
No, English, sir.
Okay. And so there was never like an interpreter involved, right?
No, he didn't need one at the time.
Okay. He was cooperative with you, right?
Yes.
Okay. And he answered your questions after you had placed him into custody?
He did.
Okay. I guess you say that Mr. Garcia had said that he had alcoholic drinks or a couple drinks.
He did, yes, sir.
Do you remember what exactly he said to you?
Not exactly. I believe just that he's had some drinks. He's had a few drinks.
Okay. When in your interaction did he say that?
He said that right after I asked him why he didn't stop.
Okay. Did you ask him what he had had to drink?
I asked him after I read him his Miranda, then I asked him that, not prior.
Okay. And did he tell you?
No, he didn't.
Okay.
So if you got bored and weren't listening, the guy got pulled over and the guy got out of his car right away. And because there was a little bit of a looting going on, The officer put him in handcuffs right away. Boom, right in handcuffs, and then started to talk to him. So they're saying, nope, no Miranda. So none of those questions count. They're just trying to see if they can get this testimony into the trial.
Did he say when he had been drinking?
No, he didn't.
Did he say at any time what he had been drinking?
No, he refused to answer those questions.
Okay. Let's see. He just said he had some drinks, but did not say what they were or when they were.
No, he didn't specify.
Okay. Did you ever make any promises to Mr. Garcia that, being honest would make things better for him?
No.
Okay. And was it just you on scene when Mr. Garcia was arrested?
No, sir. I had a FTO with me, a field training officer.
Okay. What would you say the tone of your conversation was with him?
He was irate.
I would say probably about this. Maybe I'm sure when I got out and said, "Why didn't you stop?" I was probably my heart rate probably a little higher because him not stopping. If I'm getting out, he's getting out at the same time. That's a safety issue for me that I don't know why he's getting out. It's not too normal that people jump out of cars, especially after not stopping. So I would say probably a little elevated, but after we got him in the car, it was a tone just like me and you are having.
Okay. And did you ever, tell him not to go anywhere or direct his movements?
Well, I mean, I put him in cuffs and put him in my car so that
Sure.
he didn't go anywhere.
Did you do anything before that, like tell him not to go anywhere or anything like that?
Well, yeah, when I walked up and he got out of his car, I grabbed his hands to make sure he wasn't trying to leave the scene.
Okay. And when you say you grabbed his hands, did you keep a hold of him when you were talking to him, or?
It was during the handcuffing process.
Okay. So is it more or less like right when you got to him, you had grabbed his hands, or?
Well, I didn't run to him, so I was walking to him. I was like, "Hey, how come you didn't stop?" He's like, "Because I didn't want you to tow my vehicle," as he's saying that I'm grabbing his hand to place him behind his back to put him in handcuffs.
Okay. And was he saying that he didn't want his vehicle towed, I guess, before he had said he'd had a couple drinks? Like, did he say, "I don't want my vehicle towed" first?
He said, "I didn't want you to tow my vehicle." That's what he said.
And then after that, was that when he had said?
Yeah. So only question I asked him is, "Why didn't you stop?" He said, "I didn't want you to tow my vehicle. I had a few drinks."
Okay. And it's kind of when he's saying that you were grabbing his hands to put him in the handcuffs?
Yes.
Okay. Okay, I want to move on a little bit. So you said that Mr. Garcia had refused roadside testing.
Yes, sir.
Do you remember what exactly he said to refuse that?
Not exact words. I'm guessing no, but I don't know exactly.
Okay. And I guess, do you remember the exact advisement you had given him about express consent?
You are allowed
the Miranda
to
rights?
detain without Miranda, especially when they tried to elude, especially when they got right out of the car. Absolutely, you're allowed to detain without Miranda. However,
For the express consent.
Both, I guess.
Miranda, yes, I keep a Miranda card in my pocket that I read from every time I get Miranda rights.
Okay. And he didn't really say much to you after you had read him his Miranda rights, right?
Well, I told him, "Do you understand?" He said yes, and then I asked if he'd like to speak to me, and he said no.
Okay. And then you did the express consent after that? Okay. Do you remember what exactly he said to you in response to the express consent?
I don't.
Okay, I'd like to ask you just a few more questions. So, other than, I guess, Mr. Garcia's headshot at the booking, you didn't take any photos of anything in this case, right?
No, sir.
Okay. And there wasn't any body-worn camera at that time?
No, we
weren't-
didn't. As the agency, we didn't have them yet.
Okay. Did other agencies have body-worn camera at that time?
I believe so.
Okay. Do you know why your agency didn't have body worn camera?
No idea, sir. That's above my pay grade.
Okay. And you didn't have a dash cam either, right?
No, they were not installed.
Okay. And this incident happened almost 3 years ago, right?
Correct.
How many DUI investigations have you conducted since then?
I want to say maybe one other one, or this could have been my last one since then.
Okay. Been busy with some other stuff since then.
Yeah, so I was out in, yeah, it's just depending where we are in jurisdiction wise. Sometimes we have time to, try to do traffic stops. Sometimes we're going call to call to call. So it depends a lot on where I'm at jurisdiction wise.
Okay. How well do you actually remember the events of this stop specifically? I guess without your report.
Like percent, like how
Just like
percentage wise, or like a little bit.
Here, let's say 1 to 10.
Without my report from when it was, so like like the specific streets, I don't remember. I remember the car, I remember the plate, I remember him getting out, I remember the kid. So maybe a 6. I mean,
Okay.
I don't know.
You'd agree with me that you don't have like a perfect memory of events, right?
No.
Okay. All right, no further questions. Thank you.
Any redirect examination?
Very brief, Your Honor.
I'll hold you to it.
Now, Deputy Hernandez, do you recall what shift you were working on September 22nd of 2022?
I believe it would have been swing shift.
And what hours are the swing shift?
Swing shifts is 4 to 2.
4 a.m. to
4 p.m. to 2 a.m.
Thank you. And do you still work that swing shift?
We rotate shifts every 4 months.
Okay.
So currently I am on day shift. I will go back to swings the first Wednesday of September.
So, regarding possible memory of what happened, is it safe to say your report is an accurate representation of what you recall from that interaction with the defendant?
Yes.
All right, no further questions.
May this witness be released.
Yes.
Deputy Hernandez, you can step down. Thank you. Thank you for your patience. Any additional witnesses for the people?
No, Your Honor.
Any witnesses for the defense?
No, Your Honor.
All right. Argument in support of the motions. Let's see. Go ahead, Mr. Hambrick.
Sorry, just one moment, Your Honor. Okay, so in the interest of expediency, I will rest on some of these motions. There are a few things I would like to address. If I could, I guess, start with the Miranda issue. So we heard testimony today from Officer Hernandez that when he pulled Mr. Saucedo over, that they both got out of the car at the same time. And as he was approaching, he said maybe a little bit of an elevated tone, like, "Why didn't you stop?" And as it seems like contemporaneously to Mr. Saucedo responding to that, Mr. Hernandez was grabbing his hands to place him into handcuffs. Just given those facts alone, I would argue that circumstances when he made those statements were comparable to arrest, because that is actually what was happening. Mr. Garcia was being grabbed by his hands, having them placed behind his back and placed under arrest. It seemed like contemporaneously with those statements. And so I would argue that circumstances at that time, his freedom of movement was restricted to the degree associated with the formal arrest when he made those statements. And that's what I'll say for the Miranda issue. Do you have questions about that?
No.
You look like you might. In terms of the probable cause motion, and specifically with this argument going to address probable cause for invoking express consent. I don't believe that there were enough facts available to the officer at the time that express consent was invoked to reasonably lead him to believe that a DUI had been committed. In support of that, I say, so the elements for DUI obviously are that somebody needs to be under the influence to the point that they're substantially incapable of operating a motor vehicle. Even if there were circumstances to indicate that Mr. Saucedo had drinks that day, I don't think there's enough here to support that he was impaired or substantially incapable of operating a motor vehicle. In support of that, I'd say there were no other driving behaviors other than maybe driving a little under the speed limit. 20 miles per hour in a 25 mile per hour zone that would have led the officer to believe that Mr. Saucedo's driving was in any way affected, even if he had had drinks that day. And I just think there was no evidence of bad driving at that time, and no evidence from Mr. Saucedo that he felt that his driving was impaired or that he felt under the influence at that time. So that's what I'd say in support of the probable cause motion. Just there was no evidence that his ability to drive was affected in any way at that time. And they did drive several blocks, and there was no bad driving observed during that period of time. Sorry, just one moment. And I believe I did file only yesterday, so it might still be pending. But I did file a motion to bifurcate the DUI and the DUR ALC charges, mostly for the obvious reasons that the DUR ALC could prejudice the jury and lead them to believe that because of Mr. Saucedo Garcia's propensity, particularly when his license has been revoked for the same offense, that he would have committed that offense in the future. And I think largely I will rest on the motions, the written motions and the other matters.
And I guess I do want to clarify one thing. So you were right that I had a question look on my face. For the statements component of the motions.
Yes.
It sounds like there was a Miranda advisement and a Miranda waiver, and that the parties aren't challenging that or any subsequent statements. It's really just these sort of initial statements from when the parties got out of the car and the contemporaneous nature of him being placed into custody while they were being made, but nothing else related to any of those statements, right?
Yes.
I didn't hear any of what those statements were, but it doesn't sound like the parties are challenging that. So.
No, we'd not be challenging the statements for Miranda advisement, other than we are requesting that evidence of the refusal of roadside testing not be admitted in the prosecution's case in chief.
All right. Anything else?
No, Your Honor.
And Ms. Brown for the people.
Thank you, Your Honor.
And then you can address any motion you like in any order you like. But as you can probably tell, my question is mostly related, or my issue is mostly related.
Actually, he is, before the judge gives his excellent ruling. Yes, Judge, you go, Judge. I'm just happy with the judges today. The judges are normally the stars of my show. I know the the people are the people are the people, and some are crazy and some are sane and some are a mixture. But the judges are always the stars of my show because they they do a great job. They just do. So, speaking of judge, trying to find the link really, really, really quick while I'm talking. The judge it's time. It just is time. So if you're going to if you want to donate to the judge's election, I can't find the link. Unbelievable. Unbelievable. I had it ready. I will put it in tomorrow's stream. I'm gonna put his link, and I'm also gonna put. Nope. I'm also gonna put Judge Juanita's link in there too. If you guys wanted to support Judge Juanita Jackson or Judge Fleischer, tomorrow I'm gonna put the link up here, and now is the time. The election is in 2026, and it's already August. So we were going to buy him a billboard. Instead, we're just going to send him what we want to and let him use it as he sees fit for his campaign.
Related to the statements from the initial contact.
Got it. I can start with the statements. Ultimately, I'm asking the court not to grant defense's motion. Reason being, I mean, ultimately, these statements were given voluntarily when the defendant exited the vehicle at the same time as the officer in front of the I see a question coming. Oh,
Go ahead.
At the same time, in front of the residence that he parked at, indicia of intoxication was already observed. We had the bloodshot, watery eyes, slurred speech, odor of alcohol on his breath as well. Prior to this interaction, the officer even observed the defendant driving slowly. Once the defendant got out the car and was asked, why didn't you stop at the lights or the sirens? So why'd you keep driving? The response was, because I didn't want you to tow my car. And ultimately, he even admitted to having a few alcoholic drinks. Ultimately, this isn't a Miranda violation. There was no interrogation, nor was their custody at that point. Now, after he had said he had alcoholic beverages, then he was placed into custody. However, there was no interrogation at that time. The officer was investigating. Once he observed the indicia of intoxication, that's when it became a DUI investigation. Regarding the Colorado Express consent motion, I want to point to People v. Montoya for 546 Pacific 3rd, 605 from 2024, where it states under Colorado's express consent statute, any person driving in the state consents to a chemical test when requested by law enforcement officer who has probable cause to believe the person was driving under the influence. And to expand on probable cause, under People v. McCoy, 870 Pacific 2nd, 1231 from the Colorado Courts of 1994, and People v. Rogers, 68 Pacific 3rd, 486, excuse me, from the Colorado Appeals Court of 2002. In determining whether probable cause is present, the consideration must be given to an officer's training experience in determining significance of the officer's observations. Slow down. Got it, sorry. I'll restart. In determining whether probable cause is present, consideration must be given to an officer's training and experience in determining the significance of officers' observations. And even under People v. Juarez, 770 Pacific 2nd, 1286 from the Colorado Courts of 1989. Probable cause does not require direct observation of a crime. So I say all that to say the defendant knew his license was essentially revoked given the prior DUI, as seen when Deputy Hernandez ran his information through NCIC and CCIC. Essentially, he was already on notice that he wasn't supposed to be on the road, especially behind the wheel of a vehicle, and ultimately disregarded that notice and continued to drive. Not only that, exhibiting indicia of impairment. Given that he is a licensed driver in the state of Colorado, he is aware of the privilege of that it
There's an interpreter. That's why everybody's annoying us.
is to drive in the state and the consequences for not doing so. The consequences once being convicted of a DUI. And upon advisement of the Colorado Express Consent, he essentially refused chemical testing, which led us here today. And although we do not have the luxury of having body cam or dash cam to supplement the record provided, and given this did happen about 3 years ago, based upon officer testimony regarding his recollection of the events, his report is rather solid and I think good enough to reference as to what events took place that night. Regarding the motion to suppress evidence from the warrantless arrest and refusal of chemical testing. Just to make a note, provide case law for probable cause for the warrantless arrest. In People v. Castaneda, 249 Pacific 3rd, 1119 and 1122 from the Colorado courts from 2011. Probable cause may exist even where innocent explanations are offered for conduct. The fact that innocent explanations may be imagined does not defeat a probable cause showing. Instead, the police are entitled to draw appropriate inferences from circumstantial evidence. Even though such evidence might also support other inferences.
All right, lady, wrap it up. Wrap it
I know
up.
defense made an argument that the DUI elements state that one has to not be able to safely operate a motor vehicle. If they are impaired or substantially impaired. I think arguably driving below the speed limit, as well as disregarding lights and sirens for the explanation that the defendant didn't want his vehicle towed, justify the warrantless arrest of Mr. Saucedo. And ultimately, the people would ask the court not to grant defense's motions. Oh, one more. The motion for lack of reasonable suspicion. Ultimately, as the court is aware, this reasonable suspicion, one needs to look at the totality of the circumstances for the examination. Ultimately viewed in the light of the facts and circumstances known to the officer immediately prior to the stop. The legality of the investigatory stop is determined where the police have an articulable and specific basis in fact. As seen in People v. Arias, 159 Pacific 3rd.
She's done. She's done. Look, if you want to see the whole thing, let me know, and I'll upload that to Patreon. But no.
Question on September 22nd, 2022 at 6:59 p.m. or 18:59. I apologize. I'm going to take the motions a little bit ad hoc since there were a number of things to address, and I think that the parties are in agreement that sort of the main issue is the statements motion that was filed and whether or not the defendant was in custody for purposes of Miranda at that encounter. First, noting the reasonable suspicion motion, that motion will be denied. Deputy Hernandez was able to contact the defendant just based on the license plate not being registered to that vehicle. That's the basis for the stop and what gives him reasonable suspicion for the contact and then his subsequent eluding behavior. So that motion is denied. Find that there was a reasonable articulable suspicion. based on the testimony regarding the license plate hanging on by one screw, couldn't observe the date tabs. And then when he ran the license plate,
Wait, is that
he noted
bad?
that it was registered to a Acadia, a GMC Acadia, which is not the make and model of the vehicle in question. In terms of the motion to suppress the refusal to perform roadside sobriety tests, that's granted in part during the court's general standard order. He has the right to refuse a search under the Constitution. Roadside sobriety tests do constitute a full search for purposes of the Fourth Amendment. But if the defense does open the door to a lack of investigation during their cross-examination, the people may introduce that refusal during a redirect examination. I just ask that the parties approach during trial if they think that's become an issue before we introduce that evidence to the jury, just so that the court can make any additional findings. In terms of the motion to suppress based on a
And here
lack
we
of
go.
probable cause or express consent, court will deny the motion. I do find that there was probable cause to invoke express consent.
The wrong one. He's coming. It's
It's
coming.
based on the license plate not matching with the vehicle, the subsequent eluding behavior, the statements made by the defendant that he had consumed alcohol, the bloodshot, watery eyes that were observed, the odor of an unknown alcoholic beverage that was both present on the defendant outside of the vehicle and then after he was placed in the patrol car. In terms of the motion to suppress statements, again, that is where the court
Here we go.
is going to spend the
Here we
majority
go.
of my ruling. I think that's the main issue. I'm starting off with the standard under People v. Willoughby, 524 Pacific 3rd, 1186. The Fifth Amendment to the United States Constitution provides that no person shall be compelled in any criminal case to be a witness against themselves. To protect this privilege, officers must provide certain warnings to individuals prior to subjecting them to a custodial interrogation. To determine whether an individual is in custody for purposes of Miranda, the ultimate inquiry is whether there is a formal arrest or a restraint on a freedom of movement to the degree that is associated with a formal arrest. This depends on the objective circumstances of the interrogation, not on the subjective views harbored by either interrogating officers or the persons being questioned. Courts must look to the totality of the circumstances to determine whether an individual was in custody, and there is a list of a non-exclusive list of factors, including the time, place, and manner of the encounter. Time, place, and manner, that's freedom of speech. Time, place, and purpose of the encounter. Persons
It's
present
okay,
during the
Judge. You're doing
interrogation.
good.
The words spoken by the officer to the defendant. The officer's tone of voice and general demeanor. The length and mood of the interrogation. Whether there's any limitation of movement placed on the defendant. The officer's response to any questions. Whether directions were given to the defendant. And any verbal or nonverbal responses to such directions. Deputy Hernandez indicated that his tone was slightly elevated based on the prior eluding behavior, and that is why he approached Mr. Saucedo and placed him into custody so quickly, noting that it's unusual also for an individual to get out of their car. believe that's also done for officer safety. I don't think that there's any fault towards Deputy Hernandez for that. And then the physical contact that was made with Mr. Saucedo so quickly. But the question for the court is whether that arises to the level of custody to where Deputy Hernandez had to give Miranda warnings to Mr. Saucedo before asking him any questions. It's the difficult portion for the court is that these things essentially happen contemporaneously. But I will find that he was in custody based on that physical contact. The testimony is not in contention from either party, is that he was immediately placed into handcuffs. His hands were grabbed. And that was when he began to give the responses. If he had not been placed into custody or there had been no physical contact, if his degree of movement wasn't limited in any way, and Deputy Hernandez had still asked him the questions and Mr. Saucedo had answered, those would be admissible. They would not have been made while he was in custody. But given the physical limitations and that he was placed into custody at that point, the court will find that Miranda warnings were required before any custodial interrogation could take place.
I hate this mute button. I hate it. I hate it. So every single thing he said as soon as the handcuffs touched him until he was Mirandized, not allowed in trial. They're not allowed to put that in trial at all. And I agree. Everything he said before the cuffs touched him, like I didn't pull over because I didn't want my car towed and I've been drinking. That is allowed in. Everything he said after the Miranda was given, that's allowed in. But everything he said in that moment, once the handcuffs touched him and he was thrown in the back of the police car until they actually gave him his Miranda warnings, that's not allowed in court at all. So I think that's why he's going to trial. He's going to lose because he said, because I was drinking before he was handcuffed. But we all know this. Sober us all knows to shut up, just to not talk about things in front of the police like that. We all know that. But the problem is, drunk us likes to talk and talk and talk. So I don't know. I don't know. I don't think it matters because he admitted it before the cuffs actually went on. But if I was this officer, I would have done similar to what he did. If the guy tried to flee and then when he finally pulled over, got out of the car right away, I would have cuffed him. I would have cuffed him. And there is no body cam. They didn't have the body cam 3 years ago. I don't know if they do now. There is no dash cam. They didn't have the dash cam 3 years ago. I don't know if they do now. But I agree with the judge's decision. They, he can't use it. He can't use it. Yeah, I mean, days of us saying those words are getting, slim to none. I mean, we still say them, and mostly because the cases take 3 or 4 years to go to trial. You know what I mean? So, so in 3 or 4 years, we will hear that every once in a while in a small town, but we won't hear that much. Just like the Georgia case 2 days ago, I think, yesterday. I don't freaking know. They the one officer had a dash cam, the other officer had a body cam. All right. you should get popped right over to OJ. Thank you for coming out today. I just posted the live stream. We're having a special live stream on Sunday, 1 hour long-ish. I just want to thank you guys for all the support that you've given me. So I'm going to be gifting 60 free memberships. Make sure you pop by and chat a bit. I think that helps your chance of getting a free membership. I don't know. But make sure that your gifting is on. And if you don't know what I mean, Google it so that your gifting is on. I'll see you all again soon. Bye, guys.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Dreaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way.